Trump's secret documents versus Hillary's emails. Lock her up. No, lock him up. Lock them up? Former President Trump has been fighting to contain and fundraise from the political fallout after the FBI executed a search warrant at his residence at Mar-a-Lago. We have since learned that agents sought to recover classified documents being stored on site, including confidential documents relating to nuclear weapons or energy. Among the items seized by FBI agents were at least 11 sets of classified documents, 4 marked top secret, 3 marked as secret, and 3 marked as confidential, the lowest level of classified information. After the warrant was unsealed, or at least parts of it, we learned that the FBI is investigating the former president for potential criminal violations of the Espionage Act, obstruction, and destruction of records.
Were they looking for the Hillary Clinton emails that were deleted, but they are around someplace?
In response, several of the ex-president's defenders in Congress have seamlessly flipped from back the blue to defund the FBI. Other allies have opted to invoke their favorite defense of all things Trump, but her emails. And by her, I mean Hillary Clinton, whose use of a private email server while serving as Secretary of State resulted in multiple investigations into her handling of classified information. And many of Trump's defenders have claimed that he is a target of a double standard and a political witch hunt compared to Hillary Clinton. Senator Lindsey Graham even went on to Fox News to suggest that prosecuting Trump while not prosecuting Clinton would result in massive rioting.
If there's a prosecution of Donald Trump for mishandling classified information, after the Clinton debacle, which you presided over and did a hell of a good job, there'll be riots in the streets.
Now, at least facially, this comparison doesn't seem crazy. So let's compare the investigations into Hillary Clinton's private email server with the FBI seizure of Donald Trump's top secret documents at Mar-a-Lago and address whether Clinton received preferential treatment compared to the former president when it comes to handling of classified material. So what was that whole scandal about? Well, in January 2009, Clinton aides set up an email domain called clintonemail.com on a private server located at her Chappaqua, New York home. While running the State Department, Clinton exclusively used email addresses connected to that private server for both work and personal emails, rather than using a state.gov email for government work and a separate private account for her personal affairs. In May of 2014, the House of Representatives voted to create a select committee to investigate the 2012 terrorist attack on government facilities in Benghazi, Libya, that killed 4 Americans, including Ambassador Chris Stevens. And on March 2nd, 2015, Clinton's private email server became a national story when the New York Times ran a front-page article on the subject. The article detailed that the system, quote, may have violated federal requirements and was characterized as alarming by current and former government archive officials. Clinton claimed she set up her own email for convenience, so she would only need to carry one smartphone with one email rather than 2 devices for work and personal affairs. But skeptics believe the more likely explanation was that Clinton, who was gearing up to run for president, wanted to be the sole arbiter of what emails were personal and what emails were government business that needed to be turned over in response to Freedom of Information requests and congressional inquiries. And Clinton's team did decide on their own what emails needed to be preserved and which did not, igniting a firestorm from critics that exists to this day. And on March 10th, 2015, Clinton's office disclosed that she kept 30,490 work-related emails and deleted approximately 31,830 emails that she had deemed personal, which she described as communications about private matters like yoga routines, her daughter's wedding, and her mother's funeral. However, it turns out those emails had only been intended to have been deleted and had not actually been deleted until 3 weeks after Congress subpoenaed Clinton's Benghazi-related emails. And back in December 2014, Clinton's former chief of staff, Cheryl Mills, had told Platte River Networks, the company that was managing the private server, that Clinton, quote, decided she no longer needed access to any of her emails older than 60 days. Mills instructed an unidentified PRN employee to modify the email retention policy to reflect this change. However, the PRN employee mistakenly did not implement this change and did not delete the old emails when requested. Sometime between March 25th and 31st, 2015, this employee erased the emails using a free utility program called BleachBit. Clinton later told the FBI that she was not aware that the emails were deleted in late March 2015, and a Clinton campaign spokesman claimed that the PRN employee was advised to retain all data in compliance with the congressional subpoena, but acted on his own to complete the prior deletion request. In September 2015, investigators with the FBI were able to recover some of the deleted emails. Clinton's critics have accused her and her aides of deleting emails that were under subpoena to cover up wrongdoing. Of course, during the campaign, chants of lock her up were regular features at Trump rallies, while Trump himself famously invited Russia to hack Hillary Clinton's server to find the deleted emails.
Russia, if you're listening, I hope you're able to find the 30,000 emails that are missing. I think you will probably be rewarded mightily by our press.
But in July 2015, inspectors general at the State Department and the Director of National Intelligence asked the DOJ to review whether classified information was compromised by Clinton's use of private email. The following month, it was confirmed the FBI was investigating whether Clinton or her staff violated federal laws governing classified information and whether foreign powers or hostile actors had hacked the private server. The FBI investigated Clinton under 3 criminal statutes: 18 U.S.C. 793, which makes it a felony to mishandle classified information in an intentional or grossly negligent way; 18 U.S.C. 1924, which makes it a misdemeanor to knowingly remove classified information from appropriate systems or storage facilities; and 18 U.S.C. 2071, which makes it illegal to willfully and unlawfully conceal, remove, or destroy federal records. And on July 5th, 2016, FBI Director James Comey held a press conference announcing the department's conclusion that no reasonable prosecutor would bring a criminal case against the former Secretary of State due to lack of requisite criminal intent. Nevertheless, Comey also famously remarked that Clinton and her aides were, quote, extremely careless in their handling of very sensitive, highly classified information. And on October 28, 2016, 11 days before the election day, Comey announced the FBI was reviewing new emails that could be relevant to the probe of Clinton's server. The emails were being examined as part of the FBI's investigation into disgraced former Congressman Anthony Weiner, who was the estranged husband of top Clinton aide Huma Abedin. In a November 6, 2016 letter to lawmakers, Comey announced his agency's review of emails was complete and it did not alter the previous conclusion that Clinton should not be prosecuted. 2 days later, Clinton was defeated by Donald Trump in the presidential election. And while there are conflicting accounts of the emails at issue, it seems that of the tens of thousands of emails that were reviewed, 113 were found to contain classified information, and only 3 of those had classification markers. 65 of those emails were deemed secret and 22 deemed top secret. In 2016, Comey said that Clinton should have known that some of those 113 were classified, but noted that there were others that she might have understandably missed. On June 14, 2018, the DOJ's Office of Inspector General released a report on the FBI and DOJ's handling of the Clinton investigation. The report found no evidence of political bias and reaffirmed the decision not to prosecute Clinton. And in September 2019, a 3-year State Department investigation concluded that 38 current and former State Department officials were culpable in 91 cases of sending classified information that ended up in Clinton's email server. Though the report stated that the private email increased the vulnerability of classified information, investigators found, quote, no persuasive evidence of systemic, deliberate mishandling of classified information. But let's compare that to what we know right now about the Trump Mar-a-Lago scandal, which admittedly is absolutely not complete information at this time. But after the FBI executed a search warrant on Donald Trump's Mar-a-Lago estate, the former president posted a statement on his social media platform, Truth Social, attacking what he called the, quote, weaponization of the justice system, calling the search political targeting at the highest level. Trump claimed that there was a double standard with how the FBI handled Hillary Clinton's email investigation. Quote, Hillary Clinton was allowed to delete and acid wash 33,000 emails after they were subpoenaed by Congress. Absolutely nothing has happened to hold her accountable. Now, putting aside that Clinton did not literally cover the server in bleach, obviously you take that internally to fight COVID, Trump and his allies have long suggested that Hillary Clinton should have been prosecuted, or at least, at a minimum, prosecuting Trump would be unfair of the double standard created for Clinton. But the use of private emails and other unofficial communications for government employees has come up more often than you'd think, with varying degrees of uproar and concern. And though that certainly doesn't excuse Clinton's behavior, it's probably important to look at other context and comparisons. Among those who recently used private email accounts to conduct official government business in the Trump administration, that includes advisor Stephen Miller, former Chief of Staff Reince Priebus, former National Economic Council Director Gary Cohn, former Deputy National Security Advisor Katie McFarland, and former advisor Steve Bannon. Trump's son-in-law Jared Kushner and daughter Ivanka Trump, both presidential advisors, used either personal email accounts or the messaging app WhatsApp to conduct official business. And since WhatsApp messages are encrypted, there's no record of the message unless Jared and Ivanka actually stored copies of those messages. Kushner's lawyer said his client, quote, took images of communications from WhatsApp and forwarded them to official accounts. But when asked if Kushner used the app to share classified information, his attorney demurred, saying, quote, that's above my pay grade. Former White House trade advisor Peter Navarro, also fighting contempt charges for refusing to testify to the January 6th committee, is currently embroiled in his own presidential records dispute with the National Archives. In August 2022, the DOJ sued Navarro Navarro claiming he refused to turn over emails retained on a private account while working for the Trump administration. And even Colin Powell, who served as Secretary of State under George W. Bush from 2001 to 2005, acknowledged using a laptop on a private line for State Department business, including sending notes to ambassadors and foreign ministers via personal email. And in a January 2009 email exchange with Hillary Clinton, Powell told incoming Secretary of State that he used a private phone and computer to do business with foreign leaders and communicate with senior department officials on their own personal email accounts. While Powell said that Clinton was not influenced by his email with respect to setting her up on her own server, he also said he was, quote, not aware at the time of any requirement for private unclassified exchanges to be treated as official records. But again, to emphasize, this is all bad. It's a problem in Washington, whether it's Hillary Clinton or anyone else doing it. Now, before we get to the legal consequences, let's compare and contrast some of the factual differences, because some of them just jump right out. First of all, at the time of this particular scandal, Hillary Clinton was a government employee. In fact, she was Secretary of State, just a few rungs below the President of the United States. She was conducting government business at the highest levels. She had an active security clearance, and she had communications with other people who had security clearances to view the classified documents and classified information. And she was conducting government business on a private server, which she absolutely should not have been doing, and ironically was a violation of the PRA, the Presidential Records Act. And while there's no doubt that classified material got mixed in, by all accounts this was an inadvertent mishandling. In contrast, Donald Trump is not currently a government employee. He doesn't have any security clearances at all. He was not communicating with people with security clearances. In fact, we don't know who had access to these documents. Odds are none of these people had the kinds of clearances required. And we don't know to whom these documents were transmitted or had access to them. And while it's possible that Trump's possession of these government documents started out as inadvertent, it appears clear that at some point down the chain, it was intentional and conscious to withhold these documents from being returned to the government. There's also a volume and number difference. In Trump's case, we're talking about hundreds of classified documents, potentially thousands or tens of thousands of pages of classified material. We can tell from the photographs that many, if not all of these documents are clearly marked as classified or top secret, versus a comparatively small amount in the case of Hillary Clinton. You have 113 emails that contain classified information, only 3 of which were marked as confidential. And while it wouldn't change the underlying culpability, there was a big difference in how the situation was handled once discovered. Hillary Clinton cooperated with the DOJ's investigation. It doesn't appear that Hillary Clinton ever represented that everything had been turned over when it clearly hadn't. In comparison, Donald Trump, it seems, consciously hid the documents, refused to turn it over, and lied to investigators. But just because the situation is different doesn't mean that Hillary Clinton should not have been prosecuted. So let's talk about the charge that she received preferential treatment. On July 5th, 2016, FBI Director James Comey held a press conference where he made the following statement.
Although we did not find clear evidence that Secretary Clinton or her colleagues intended to violate laws governing the handling of classified information, there is evidence that they were extremely careless in their handling of very sensitive, highly classified information.
So was Comey's statement that no reasonable prosecutor would bring a case correct or evidence of political bias? Well, in 2016, the FBI told the Senate Judiciary Committee that, quote, extremely careless was Comey's common sense way of describing the actions of Clinton and her colleagues and was not intended to describe the legal standard for gross negligence under the Espionage Act. But Trump and his supporters have argued if Clinton was indeed extremely careless with the classified materials, the failure to prosecute her, at least for grossly mishandling classified material under the Espionage Act, was a miscarriage of justice. But it's not enough to look at the statute, we have to look at how prosecutors have brought charges under the section. Now, back in 2016, Andrew Torres, the lawyer and host of the podcast Opening Arguments, which is excellent, researched all prosecutions under the Espionage Act. And out of 240 cases, Torres only found 9 cases that had been brought under the gross negligence part of the statute. And in all of those gross negligence cases, the defendant was found to have made, quote, a deliberate decision to hide or destroy information that the defendant knew to be confidential and improperly in his possession. Torres concluded that Comey's statement that no reasonable prosecutor would bring a case against Clinton was correct, writing, quote, I can find no case anywhere in which any person has ever been sentenced under the Espionage Act without evidence that said person unambiguously knew the material that they were removing was confidential. Since that fact is not present here, I conclude that Hillary Clinton received no special treatment when the government declined to indict her.
We're talking about 18 U.S.C. 793. That's the Espionage Act. Act. It is the same law with some amendments that was used to prosecute Julius and Ethel Rosenberg. Virtually all of the prosecutions under it are for what we typically think of as spy stuff, right? Someone with access to documents that relate to the national defense steals or makes a copy of those documents, and prosecutors don't even have to prove that person ever sold it to a hostile foreign power or another spy. You just have to prove that they took the document. You can infer that they weren't going to do anything good with it. And while espionage no longer carries the death penalty, it is a felony with a 10-year maximum sentence. And that's why we never find any cases that are even a close analog to Secretary Clinton's conduct. It isn't espionage. When someone leaves a file cabinet or a door unlocked or leaves a top secret document out on their desk, that's certainly extremely careless, but those cases aren't considered espionage. And you probably noticed I use the weasel word virtually. Virtually all the prosecutions under the Espionage Act are for spy stuff. But what about the handful that aren't? Consider U.S. v. Gonzalez. This involved an Air Force staff sergeant who was stationed in Anchorage, Alaska, and was taken off to go party with his buddy who worked for an oil company. Sarge grabbed a bunch of his stuff to give to his buddy, and while doing so, accidentally grabbed 2 classified documents. When he got to Prudhoe Bay, he discovered his mistake, but instead of calling his superior and owning up to it, he told his buddy, "Hey man, I'm just going to stick these 2 documents in your desk and totally make sure you remind me before I leave to take them back with me to the Air Force Base, okay?" For whatever reason, use your imagination, the Sarge and his buddy totally spaced on the documents and just left them there in the desk. That might not have been such a big deal, except that the buddy didn't actually have his own desk. He shared it with another guy named Nick, and Nick got to work Monday morning, opened up his desk drawer, saw the bright red confidential sticker on the cover sheet of the 2 documents, and freaked out, as you do. He called his boss called the Air Force, and one thing led to another. Sarge was sentenced to 43 days of confinement, a little less than the 10 years, discharged for bad conduct, reduced in rank. Or consider U.S. v. Gaffney, which coincidentally involved another Air Force staff sergeant, although this guy would never, ever trek off to northern Alaska for a weekend-long bender. No, this guy was a good family man. He just wanted to spend more time at home with his pregnant wife, and so he did. But one of Sarge's job duties was to shred classified documents, and being that this was 1982, shredders were super slow. Rather than spending hours shredding documents like a dumbbell, he did what, anybody with a pregnant wife might do. Grabbed all the documents and deposited them in a nearby dumpster. Problem solved. But except that helicopter parenting wouldn't be invented for 2 decades, so kids played in dumpsters all the time. Some rugrat found the documents, took them home, Daddy found them under the bed, hey, could have been worse, and called the Air Force. All of these cases that don't quite fit into the spy stuff category are like this. They're cases in which the defendant absolutely knew that they had compromised documents in their possession, and then they still did the stupid thing, and then they tried to actively cover their tracks. As Jim Comey put it, all of the cases prosecuted involve some combination of clearly intentional and willful mishandling of classified information, the very behavior for which Secretary Clinton was exonerated.
But look, don't take legal advice from a podcast. Take legal advice from a YouTube channel. But why would prosecutors only bring cases involving deliberate conduct when the statute requires only gross negligence? Well, that's because the gross negligence statute might be unconstitutionally vague. Under the vagueness doctrine, statutes that are vague, indefinite, or uncertain violate due process because such laws fail to give the individual proper notice of how to conform their conduct to follow the law. And in a case called Gorin versus the United States, the Supreme Court suggested that the then operative provisions of the Espionage Act was not unconstitutionally vague only because it criminalized intentional conduct. Quote, "The obvious delimiting words in the statute are those requiring intent or reason to believe that the information to be obtained is to be used to the injury of the United States, which requires those prosecuted to have acted in bad faith." And in an August 16, 2016 letter explaining the decision not to bring the charges, the FBI told the Senate Judiciary Committee that the DOJ had only prosecuted for intentional mishandling of documents because the gross negligence language is likely unconstitutional. They said, quote, "There are concerns about the constitutional implications of criminalizing grossly negligent conduct without requiring the government to prove that the person knew he or she was doing something wrong." The letter noted that only one person in 99 years had been charged with mishandling classified documents in a grossly negligent way, a charge that was dismissed when the defendant pleaded guilty to making false statements. So, given the potential unconstitutionality of gross negligence prosecutions, the DOJ has opted to almost exclusively prosecute cases involving only intentional misconduct. But is Trump subject to an unfair double standard by law enforcement? Well, so far legal experts are pretty much unanimous that Trump's case is much, much worse, and it's not subject to a double standard. As more information about the FBI's search has been released, legal experts have weighed in on whether Trump has been treated unfairly when compared to Clinton. David Loftman, who headed the Justice Department's counterintelligence section until 2018, said there's simply no comparison between Clinton's emails and the judge-approved search of Mar-a-Lago. Quote, "People sling these cases around to suit their political agenda, but every case has to stand on its own circumstances. For the department to pursue a search warrant at Mar-a-Lago tells me that the quantum and quality of the evidence they were reciting in a search warrant and affidavit that an FBI agent swore to was likely so pulverizing in its force as to eviscerate any notion that the search warrant and this investigation is politically motivated." And Loftman has experience in this area. Not only did he personally oversee the investigation into Hillary Clinton's emails, he also managed the investigation into David Petraeus. And here's a quick summary of what led to the FBI getting a search warrant to recover classified documents and presidential records from Trump's residence at Mar-a-Lago. When Trump left office in January 2021, boxes of records that his White House counsel said should have gone to the National Archives were instead shipped to Trump's residence at Mar-a-Lago. Officials at the National Archives spent 8 months in negotiations with Trump to return the documents. 15 documents were returned in January 2022. Upon reviewing the documents, though, NARA saw documents clearly marked classified intermingled with non-classified info, resulting in a referral to the DOJ to investigate possible mishandling of classified material. The FBI had evidence that dozens of additional boxes with classified info were still being kept at Mar-a-Lago, so the DOJ obtained a grand jury subpoena seeking documents bearing classification markings that were still in Trump's possession. On June 3rd, Trump's custodian of records turned over additional boxes to the DOJ, then signed a certification swearing that a diligent search had been done and all responsive documents produced. Trump's lawyer told the FBI agents that all boxes of classified records had been kept in a secure storage room. However, the FBI uncovered multiple sources of evidence that the response to the grand jury subpoena was incomplete and the classified documents were still on site. The FBI also had evidence that, quote, government records were likely concealed and removed from the storage room, and that efforts were likely taken to obstruct the government's investigation. So it's against this backdrop, over a year of delays in returning all classified documents voluntarily, not turning over documents in response to the subpoena, and evidence of obstruction of justice, that the government finally got a search warrant for Mar-a-Lago and conducted the search. Of course, we got more information on August 18th, 2022, when Judge Bruce Reinhart, the magistrate overseeing the Mar-a-Lago search, unsealed the warrant cover sheet, revealing the FBI was investigating potential violations of 18 U.S.C. 793, willful retention of national defense information, 18 U.S.C. 2071, concealment or removal of government records, and 18 U.S.C. 1519, obstruction of a federal investigation. Clinton was also investigated for violating Section 2071. But Bradley Moss, a well-respected lawyer who handles national security cases, said that the cases of Clinton and Trump are significantly different given Trump's willful retention of classified documents. Quote, Trump took properly marked hard copy classified documents from the White House, shipped them to Florida, and stored them in an unsecured location at his residence. Moss also noted that while some Trump documents were clearly marked as classified, the presence of classified information in Clinton's emails was less obvious. Quote, the emails were never marked as classified because there were communications from unclassified government accounts. And similarly, the FBI's August 2016 letter justifying its decision not to charge Clinton, the Bureau noted how past prosecutions involved some combination of clearly intentional and willful mishandling of classified info, significant quantities of classified info exposed to support an inference of intent, or indications of disloyalty to the United States, none of which were present with Clinton. As examples, the FBI cited past prosecutions of ex-CIA Director David Petraeus, who knowingly exposed significant classified materials to his biographer turned mistress and then lied lied about it when confronted, former Bill Clinton National Security Advisor Sandy Berger, who stole clearly marked classified documents from the National Archives by hiding them in his clothes, and Afghanistan naval reservist Brian Nishimura, who removed hundreds of clearly classified documents from classified U.S. military information systems, lied to investigators about them, and then destroyed large quantities of classified documents. Contrasting these cases with the Clinton case, the FBI highlighted Clinton received 3 emails containing C markings for confidential, and that wasn't clear evidence of knowledge or criminal intent. As further evidence of lack of criminal intent, the FBI highlighted that Clinton did not originate this information, but rather the email chains were forwarded by staff members with the confidential markings buried deep in the email threads. The DOJ's 2018 report on Clinton's emails also concluded that the classification markings were not clear. In addition, over 2,000 emails were retroactively characterized as including classified information, which underscores the uncertainty regarding the status of Clinton's emails. In Trump's case, the ex-president was explicitly notified not only that he was illegally in possession of highly classified documents, but that the DOJ and intelligence community had concerns that those classified items were not safely stored. According to the Wall Street Journal, an individual familiar with the boxes from NARA had alerted investigators that the documents were not being stored securely, which heightened the agency's urgency to seize the documents. In the May 10, 2022 letter, NARA informed Trump's attorneys that the boxes recovered from Mar-a-Lago in January contained more than 700 pages of classified material, including documents marked extremely sensitive. And after reports from inside Mar-a-Lago that individuals were seen moving boxes in and out of the room, in June of 2022, the DOJ subpoenaed the Trump Organization for Mar-a-Lago security footage of the area. Since the search, the government has recovered more than 300 documents with classified markings. And according to the partially unsealed affidavit that gave rise to the search warrant, NARA referred the matter to the DOJ for investigation following a preliminary review of 15 boxes of documents. NARA warned the DOJ that classified documents were haphazardly mixed with, quote, newspapers, magazines, and printed news articles, among other items. Of most significant concern to NARA, the classified records were unfolded, intermixed with other records, and otherwise improperly identified. These fears were confirmed when agents who searched Mar-a-Lago, quote, found highly sensitive and classified documents lying in unsecured places outside the storage room that the Justice Department officials had earlier asked to be better secured. When the FBI conducted a preliminary review of 15 boxes that Trump finally turned over to NARA in May of 2022, the agency discovered that Trump was in possession of at least, quote, 184 unique documents with classified markings, including 67 documents marked as confidential, 92 documents marked as secret, and 25 documents marked as top secret.
If you're the president of the United States, you can declassify just by saying it's declassified, even by thinking about it.
The affidavit further alleges that the return boxes include classified documents related to, quote, clandestine human sources who help U.S. intelligence gathering, as well as how it conducts foreign surveillance and information under lawful domestic surveillance. These are some of America's most closely held secrets, and disclosure of this information could lead to sources being compromised or killed. And the intermingling of personal papers with these highly classified documents, as well as their location in what is reported to be the former president's personal desk, all go to state of mind, and that former President Trump may have intentionally kept these documents and been actively reviewing them long after they were requested by the government.
Presidents leave, they take things, they take documents, they take things, they read them.
Clinton was comparatively more cooperative with the DOJ's investigation of her server than Trump has been with his classified documents, which forced the DOJ to be more aggressive with Trump. Clinton critics would likely dispute such a characterization, though, noting that 30,000 emails were deleted weeks after Clinton received a congressional subpoena, though the deletion was apparently by an unidentified server employee. Clinton defenders would counter that she did voluntarily turn over her private email server to the DOJ in August of 2015, and the following month the FBI was able to recover many of the deleted emails. Clinton also voluntarily met with the FBI for a 3.5-hour interview on July 3rd, 2016. In contrast, Trump was vehemently opposed to turning over the documents voluntarily, even in response to a government subpoena, which is why a search warrant was apparently required to get the documents back. The redacted affidavit alleges that NARA began making requests for the documents' return in May of 2021, and it took 8 months of delay before Team Trump informed NARA that there were boxes to be recovered. On August 16, 2022, the New York Times detailed additional efforts by the FBI to recover NARA's documents, and the article highlights how Trump blew off demands to have the documents returned, telling several advisors, quote, "It's not theirs, it's mine." Now, if you'd like to hear more about the legal misfortune about people in the Trump orbit, you can watch an entire exclusive video we did about Steve Bannon's upcoming fraud trial. That's the one where he got pardoned, but then New York State went after him anyway, and it's a question of whether double jeopardy applies. But I'm sorry to tell you that that exclusive video is really exclusive and you can't watch it on YouTube. But you can see it with today's sponsor, CuriosityStream and Nebula. Because on Nebula, my videos always come out early with 0 ads, and I release exclusive content all the time, like that exclusive Steve Bannon video, or an entire video about the legal stories that are not safe for work and are too hot for YouTube, as well as things misunderstand about the Constitution, why NFTs are bad for creators, and my first full-length documentary, Bad Law Works Good. And even though this exclusive content is exclusive to Nebula, you can get access to it for free with CuriosityStream. And it's not just me. Nebula is creator-owned and creator-operated. There's exclusive content released every single day, multiple times every single day. And by the way, we've been developing Nebula like crazy. It now has apps for iOS, Android, Apple TV, Roku, Fire TV, and Android TV, and was recently nominated for its first Streamy. And we're thrilled that Nebula is partnering with CuriosityStream because they're the go-to source for the best documentaries and long-form educational content on the internet. They even have an entire section devoted to unsolved mysteries and crime, so if you like my videos, you'll love the thousands of titles on CuriosityStream. Now, the best way to get access to Nebula and all of the incredible content is through the amazing CuriosityStream Nebula bundle deal, with its current sales price of less than $15 per year to get access to both sites. And to be clear, that Nebula subscription is not a trial, it's free for as long as you're a CuriosityStream member. There just isn't a better deal in streaming where you get access to 2 great streaming sites with content that you'll actually watch and enjoy, all for less than $15 per year at the current sales price. And what's more, signing up will actually help countless independent educational creators beyond just LegalEagle. So sign up right now by clicking on the button that's on screen right now or down below in the description. It's a great way to support educational content and tons of exclusive content that you'll love. So click on the link that's on screen right now. And after that, click on this box over here for more LegalEagle, or I'll see you in court.